decision was taken to put up a national cathedral at where these 12 appeal court judges and their families were living. In fact, at the time, the information is that there were even some bungalows that were still under construction. The bungalows they were living in were less than, in some cases, 5 years old. I have also noticed recently that there's judicial service lands around the cantonments area, near the Namibian High Commissioner's residence, where some, judges were housed, around Elwak. I've noticed that it has been taken up by private developers recently. Now, my question is, what will be your, and maybe related to this also are reports of the decay that we see at the recently constructed Supreme Court building. That's just less than 5 years old. The court complex. What will be your attitude towards the preservation of these lands or assets or properties belonging to the judiciary? And do you know if those 21 ultra-modern apartments that were promised when the 12 judges were relocated have been delivered? Thank you.
Yes, they have been delivered. I actually live in one of them. And my attitude to protecting the assets of the judiciary will be robust.
What does robust mean? I'm sure the viewers out there are also asking, what does robust mean? Madam?
Robust means that as an administrator, I'll be absolutely interested in knowing where all our properties are. I'll be interested in knowing what is happening with them, the state of them, and ensuring that they are well protected, because we need them.
My Lord, can I ask this question? Does judicial service own any property, or they are properties of the state allocated for the use of the judiciary?
I believe that these are properties of the state allocated to the judiciary. But if they are allocated to the judiciary, then the judiciary must be in control of them.
I understand that carefully, but I'm worried about creating the impression that it's the judiciary's property. It's a state property. The state may reallocate to somebody else.
I think that if the state is to reallocate them, it can only do that with our consent and our information. No, I don't think that the state, because we are part of the state.
Exactly the point I was seeking to make, because this definition of what the state is, I know, will take us into another realm of argument. But I hope that the chairman is not suggesting that the state refers to the executive.
Please,
that
just
can
go ahead with your question.
That can offer land and take it at will and relocate it to anybody that they want. I hope that's not what the chairman is suggesting.
If we get an opportunity, we will argue that between you and I, and I'll show how. Because if I allocated it to you, I can't take it back. That is legal. Please proceed with your question.
Well, it looks like this debate has nothing to do with you, Honorable Nominee, but I'm on your side on this, and I'm hoping that you will actually ensure that land or properties allocated to the judiciary are protected and used to the benefit of all of us, and the executive should not encroach on it at will. Now to my next question. It has to do with career magistrates. It was something that many people in that area hailed. They were happy when it was introduced. At a point, a number of them were even given study leave to go upgrade themselves. And their promise was that they will be converted to become professional magistrates. as we speak, the concern I get is that many of them have not been converted, even though they have undergone their training and returned. They have not been converted to professional magistrates. Some have been converted, but there's no criteria, there's no standard that ensures that it is monitored and it is based on merit. What will you do about that, assuming, without saying, that this house approves you to become the Chief Justice? What will you do about the fate of these magistrates who do not know when they will be converted to professional magistrates, and even how they will be converted?
I know the House will approve me, thank you. But beyond that, I think that all of these situations are covered by documentation. They're covered by records. And it's important to work with the records, the undertakings given, the actions undertaken, and how the stage at which whatever change has occurred is in. So I will work with the records. There cannot be conversations that anybody makes presumptions about. The records must speak to the situation.
My final question. I see that you are a person of faith. Membership with AGLO and all. And let me share a quote by Harold J. Berman in The Interaction of Law and Religion, where he writes, quote, "Unless people believe in the law, unless they attach a universal and ultimate meaning to it, unless they see it and judge it in terms of a transcendent truth, nothing will happen. The law will not work. It will be dead." Unquote. Honorable nominee, I've seen you, or I've heard you quote Bible verses, including Hebrew 11:1. Hebrew 11:1.
You don't know Hebrew in the Bible? It's about Hebrews.
Quote, quote, "Faith is evidence of things not seen." Unquote. I've come across you make reference to that. Faith is the evidence of things not seen. That is believing something that cannot be seen or proven with tangible evidence. And I'm struggling to contextualize that within the profession that you find yourself in, where we are told that evidence is everything. Can you educate me?
I can understand where you are coming from. It's a favorite line I use when I am teaching on certain vision, mission, and goals, which is one of the subjects I teach, which is that we always start with something that is innate, our creativity, and then it's expressed outside. So that's what faith being evidence of things not seen means. There's something inside of us that comes out. But in the context of law, law is textual, and our duty is to interpret, construe it, apply it. That's why I said earlier that when I'm in court, I have my legal head on. When I'm at home, I have my faith head on. But I never lose my Christianity in both arenas.
So there's no case
Thank
where...
you very much.
Where...
Yes, Honorable John Kuma.
Hey, chairman.
Thank you very much.
Mr. Chair, just a quick follow-up, just for the records.
Honorable Suhin.
Honorable Markin, may I give you a quote from Lord Denning? Being a lawyer, I'm sure you know of Lord Denning, one of the greatest.
Just want to.
No, I want to give him a quote.
Oh, to him.
Yes.
Okay, before. Okay, he says he can't take the quote, so it's fine.
If I'm allowed, then we can engage. Mr. Chairman, if I'm allowed, we can continue to engage. But if I've been ruled out, then she cannot no longer be making references to me.
She answered your questions. You wanted to follow up, but you had asked 4 questions instead of 3 that has allowed everybody. You wanted a 5th option, which I declined. That's right. But you.
Honorable Markin, if you don't mind, I'll give the quote to you before you go on. All experiences convince me not only that God is ever present, but also that it is by contact with the Spirit of God that the spirit of man reaches its highest and its best. This is a quotation from the Right Honorable Lord Denning in his book called The Closing Chapter.
Yeah, Mr. Chair, it's in connection with a quote from my respected colleague, Suhini. I mean, I think it was not complete. If you say faith is the evidence of things not seen and substance of things hoped for. I think that's a complete thing I just wanted to put.
Thank you.
Yes, Honorable John Kuma, please.
Thank you very much, Mr. Chairman. I want to especially congratulate Her Ladyship, Justice Gertrude Araba Isabasaki Torkornoo.
Thank you.
And I also want to use the occasion to pay special tribute to the outgoing 14th Chief Justice.
Is that intended to be a question for the new?
Yes, it will finally end into a question.
I'll be closely
Justice
monitoring.
Kwesi Eninyeabua.
Closely monitoring.
Yes, please monitor. And my question is on legacy. My observation of Chief Justice Kwesi Eninyeabua's period as Chief Justice was his focus on expansion of infrastructure and new facilities for the judiciary. And I highly commend him for that. I know you as one of the boldest voices in the judiciary currently, and I'm impressed anytime I read and hear your independent views on matters before the Supreme Court. A lot of people are looking up to you, especially our young girls. What, in your personal estimation, do you want to be remembered for as your legacy? Maybe I'm late, but okay.
Yeah, unfortunately, you are late.
Maybe I'm late on that.
He has answered that question.
Okay, so
let me ask another one.
Okay, so the next question that I want to ask will be, there is constant call on constitutional review in the country, and many of the concerns that especially non-lawyers who have called for constitutional review in Ghana have said that the president is too powerful in the 1992 constitution. Of course, as a lawyer who has seen so many clawback clauses in the constitution, I don't agree with that position. But because I'm also a politician, maybe people think politicians have different assessment of issues. Please, what's your independent assessment of the role and power of the president in the 1992 constitution? Will you call for an amendment of the 92 constitution because the president is too powerful? Thank you.
I really would not want to share any views on that subject, except in relation to the judiciary. I noticed that in Article 146, the process for removing a judge starts with a petition to the president. I do think that the work of the judiciary should not be cloistered in the hands, the origination of anything regarding the judiciary should not be cloistered in the hands of the president, so that if you have a president who does not want to remove a particular judge, and yet that judge's work is inimical. So far we haven't had any crisis, but I'm just thinking ahead. It's only in that context that I think that we need to open up some of these provisions so that individual institutions can also have a say in some of the issues that affect them in that context. But that's about the only thought I have.
Mr. Chairman, just a follow-up on that one.
That's your second question. Go ahead.
Okay, thank you, Mr. Chairman. Your Ladyship, many people have described that function of the president as only an accelerator. He is not even expected to have an opinion of that assessment. Do you agree with those who think that it's only a procedural role of the president receiving the petition and forwarding it? Do you agree with that position?
Absolutely, I agree with it. But if he doesn't forward it, what can we do?
Thank you, and I wish you well.
All right, I'll give you two. Reverend Ntumfojo, I'll give you two. Two, please.
Thank you very much, Honorable Chair, for your magnanimity. Your Ladyship, Araba Isaba Sakitokunu, JSC. Congratulations on your your nomination.
Thank you very much.
I was enjoying, and I've been enjoying your submissions, your preaching, your eloquent quotations of relevant portions of the Holy Book. And I couldn't stop admiring that in your position as a lawyer, as a legal professional, and also a member of the upper echelon of the judiciary, your personal Christian views are publicly always upheld, and that I admire. In your earlier submissions to the committee, Your Ladyship, you made reference to judicial predators and indicated that in most cases where the activities of judicial predators had been encountered, it is very likely that 9 out of 10 of proceeds from the activities of judicial predators may end up with the judicial predators, and only 1 may end up with judges. But do you agree that that may indicate 10% prevalence rate of the canker? Are you concerned about that 10%? And what steps would you take when your nomination is confirmed as Chief Justice of the Republic to address that supposedly or potential 10% prevalence and to address the activities of judicial predators? Thank you.
Yes, I'm concerned about the 10% because we ought not to have any such situation. You know, a judge is supposed to be constitutionally, under the Constitution, you must be a person of good moral character and proven integrity, and so there should not even be any whisper. That said and done, I think I've mentioned that judicial ethics is a subject that is consistently raised within our judicial training. Every aspect of our judicial training, we address the question of ethics. We work on it. We work exercises, we talk about it, we have orientation on it, and we address it. I think also that you say corruption, as you know, is an activity that occurs away from everybody's eyes. And that is why perhaps the predators have a field day, because who is to know what is going on? And so, to my mind, ensuring an active consideration by the citizenry that you ought not to be giving money to anybody because justice is your constitutional right is it may be one of the most potent forms of addressing the matter. But beyond that, I think that there would be sanctions available to address any errant behavior. And for me, it is about always ensuring that whatever activities we undertake in judicial administration are regulated by law. You cannot tamper with anybody's rights outside of propriety and legality.
Thank you very much. Your Ladyship, you also indicated further that you believe that the practice of justice is done in communities. And in that respect, I suppose that you believe also strongly that the wheels of justice ought to be running and running smoothly in every community, most communities, and equitably. Considering the current deficits of circuit courts and high courts equitably across the length and breadth of this country, what steps will you take to ensure that deficit is further addressed, considering that your predecessor did significant efforts on that? Recently, he commissioned a circuit court in my constituency together with me, and that is the first circuit court all the way from Adanse, Obuasi to Yamransa before getting to Cape Coast, that long stretch. That is the very first circuit court. And I believe that, and many such courts were also commissioned, but there's still a bit more to be done. What will you do to address that deficit in that respect?
I think the studies that have supported the work that has been done under His Lordship and in Yeboah, the studies indicated 207 courts. They identified the need to build 207 courts. So far, what has been built is fewer than that. We've made a lot of progress, but we are yet to get to the 207. So I will meticulously pursue the construction of the rest and also ensure that anything that needs to be done to get them done is done.
Thank you very much, Your Ladyship. I wish you the very best. And lastly, as a Christian and a lawyer, having indicated to us just in a short while how you've managed these two, what will be your professional legal position and your faith position on the matter of LGBTQ and the position of the Law Institute?
I think I have made it clear that when I walk into court, all my thoughts are soaked in the law.
On the law.
Yeah, so the law we make, she will implement. She will apply it.
I wish you the very best, Your Ladyship.
Thank you.
Yeah.
Allow her to speak.
Now I'm at leadership. Honorable Chief Whip.
Thank you very much, Chairman, for the opportunity. Many of my questions will be public interest questions. I am not a lawyer, so forgive me if I don't come across as such. First of all, earlier some colleagues asked you questions about, at least to us ordinary people, the question of contempt of court, especially the Supreme Court, is quite a nebulous one because we read, I've read severe criticisms of, for instance, the Supreme Court judgment in the United States, where even speakers described judgments in quite severe terms, and we don't see anything. But it's as if in Ghana, people are ordinary until they become Supreme Court judges, and they said, look, you can't say that about Supreme Court judges. What exactly
Honorable Member, that's not correct. So kindly take that out of your...
Which one is...
That they are ordinary until they become Supreme Court judges. No. It's not what you think. It's not correct, please.
Mr. Speaker.
Honorable, let me guide you. What? Honorable Suhini, please.
Okay, let me say it this way. I see ordinary people I know as lawyers, and the day they become Supreme Court judges, it's as if they are completely different human beings that must be treated. I'm saying, that is my view. Why don't you allow me? Honorable Esla, even when you were saying things about Honorable Yariga, which were not factual, we allowed you to say
proceed them. With your question, please.
Okay. Is it? Oh no, you said he came through a by-election, but that's. We have a right to do that. Chairman, is she actually the chairman currently? But if you mention my name and make an incorrect statement, then why don't you just allow me to make?
Can I have some order here? Honorable Minister, please. I haven't given you the floor. I shouldn't give you the. I haven't given you the floor. Okay. Please proceed.
Okay. Your Ladyship, is it the case that when the boundaries of what contempt is are not quite clear, people are allowed to say whatever they say, and then you say that maybe within what you understand, now you have gone beyond the boundary? My question is this. I can see that you are a scholar because you've written books and you've done certain things. Will you make a commitment to perhaps help codify what you call contempt and describe the boundaries so that in the case that somebody is making comment, the person will know that you don't have to be a lawyer, but you know that this is the boundary. Would you help or give an assurance that there will be a way to codify what is contempt in this country? Because ever so often, Your Ladyship, we've seen, even colleagues, members of parliament, one person will say one strange thing about the judiciary, and in the eye of the public, he gets patted at the back of his hand, and then another one comes from the other side, and it's as if that person is treated completely differently. And I'm saying this, you know what I'm saying. I take the case, listen, I take the case of the Muntie 3, and then our own colleague, Honorable Kennedy Ejepong. And as an ordinary person in the country, I ask myself, what is the balance? Why is it difficult for the court to come up with at least similar judgment so that we know the boundaries? So that is why I said that I'm not a lawyer. So if you answer this question, then you ask, you tell me whether it is necessary for us to codify what contempt is so that ordinary people know the boundaries within which we protect the sanctity and the integrity of our courts and the practitioners for our own good. That's my first question.
Thank you. You know, the challenge of our work is that every case is fact specific. So you have myriads and millions of different sets of facts. And then we have sets of legal principles. And our job is to apply the principles to the different sets of facts. Sometimes the law that's applicable is in statutes, sometimes is in common law principles, etc. Sometimes is in regulations, different arenas of law. That's the challenge of our work. That's the skill we apply. And therefore, I can understand why you may be confused about why this and why not that one. It may be the facts of the case. I'm not vouching for it, but it may be different facts. In asking why the Supreme Court responds, I think that I had earlier indicated that we are custodians of 400 courts, judges, hapless citizens who are doing their best. And we must ensure that the administration of justice is not denigrated in a manner that is not allowed by law. On the issue of whether the law on contempt can be codified, I think that's a very interesting request. I will look at it.
Thank you. My second question is about another public interest. Recently, there has been a ruling by the court, and on the 17th of July 2020, My Joy Online reported, and it was quoting our colleague, the deputy minister at the time of justice, as saying that, for instance, birth certificates are not a proof of nationality. And this is a comment he made in relation to a ruling from the Supreme Court. When I take the form you fill to get a birth certificate, for instance, they call it a birth registration form, Form A. B, a portion called B, particulars of mother. Under that, 9, it states a national of. So the mother has to state whether he's a Ghanaian or she's a Ghanaian or not. And then when you come to C, under that, 16, also the father, you have to state the national of the father. When you come to the certificate that is issued to the person, it is quite clearly written the nationality of the person, because the person have ticked the 2 boxes. The mother or the father is a Ghanaian. Therefore, he or she qualified to be a Ghanaian. So if today, the ruling, according to our colleague, is that a birth certificate is just a mere record of birth, what then is a proof of nationality in this country? And I will be very happy, because I see in front of me probably the most senior people in the judiciary in this country. And I think Ghanaians who are ordinary like me may want to know, if I hold my Ghanaian passport, is it a proof of my nationality? Is my birth certificate a proof of my nationality? So I want to understand the understanding of that ruling, why it is as if a birth certificate is not a proof of nationality. Meanwhile, on the form, you have to certify clearly that you are a national before you are given a certificate as a national of this country.
Honorable Member, Honorable Chair, citizenship is a matter of law. Nationality is a matter of law. Certain jurisdictions, being born in that place makes you a citizen of that country. In our country, being born in Ghana doesn't make you a citizen of Ghana. It is your relationship with your mother. It is your mother's identity, your father's identity. It is your lineage that determines your citizenship. So, that form records, that form is actually an international requirement. We must know where everybody is born. That form assists to know your antecedents. But beyond that, your nationality is derived from the information on that form. It is not the evidence of your nationality. It is the beginning of appreciating how your nationality must be determined. It's an originating process.
So if I hold a birth certificate duly issued by a state institution in Ghana, Registrar of Births and Deaths, and it states nationality, Ghanaian, are you saying that that is not enough proof of the nationality of the bearer of that certificate?
May I answer you this way? If you had an English person come and live in Ghana and have a baby in Ghana, that person would have a birth certificate. But that person's record of the parents on that birth certificate would indicate that they are not Ghanaian. So the certificate is a record of where he was born. It is not an indication of the citizenship.
I've already said that in the generation in the generation of the certificate, I quoted on birth registration form A, part B, particulars of mother, because if your mother is a Ghanaian, a child from that mother can claim.
Honorable member, from the birth certificate, if your mother is Ghanaian, if your father is Ghanaian, then we can conclude that you are Ghanaian. But from that certificate, if your mother is not Ghanaian, your father is not Ghanaian, that certificate is a record that you are not a Ghanaian. So it is a record that allows us to, I am doing legal deduction. I don't know how else to express myself.
So can I use a birth certificate issued by the births and deaths in this country that says I'm a Ghanaian? Can I use it to prove my nationality as a Ghanaian?
The birth certificate will never tell you that you are Ghanaian. The birth certificate records where you were born and the nationality of your parents.
So the information on that certificate that says that my mother is a Ghanaian, my father is a Ghanaian, would that be sufficient to prove my nationality as a Ghanaian?
Will be sufficient to arrive at the conclusion that you are Ghanaian. It's the beginning point.
Karen, your ladyship. Order, the heckler. Your ladyship, can a Ghanaian passport holder use a Ghanaian passport as proof of being a Ghanaian?
I believe so. Because before you arrive at the passport, all your antecedents, such as a birth certificate, would have been evaluated.
By your, I'm saying it in a very respectful way. By your age, I don't know where my birth certificate is today. By your age, it is more likely that if you are asked to prove your nationality, you might produce your passport rather than birth certificate. Is that the case?
I have my birth certificate.
Okay, what Mr. Speaker, once she offered that she's got it, can she produce it to be added? Oh yes, to be added to the document. Yes, Mr. Speaker. I did not ask for it. She volunteered it, so if she can add it to the document we are requesting.
Let's proceed with your further questions, please.
I have another question. Currently, we have the three arms of government we have. We have 275 members of parliament. Chances are that we come from almost every corner of this country to represent the good people of Ghana. In the appointment of ministers, the executive, the president, takes that into account, and as much as possible appoint people, ministers, and so from various parts of the country, because it's enjoined to do that as much as possible according to the Constitution. Public perception sometimes is such that there are sections of the public that believe when judges are appointed, especially judges of the higher courts, the spread of their locations from the country is not representative of the broad spectrum of the country. I'm just saying that it's a speculation. In the administration of justice, is it necessary to have justices coming from across the country? Because I know in Parliament we say that the police, the military, and everything should be a spread of the country, so that even the way they do their work will be easier for them. In your view, do you think that in the appointment of judges, that spread should also be taken into account?
I think diversity always enriches every group. And so if any group has different ethnic backgrounds, gender backgrounds, faith backgrounds, it enriches the quality of thinking.
In your earlier answer to a question about Article 71, you rightly said that indeed the judiciary's salaries or remunerations are determined as it is for members of parliament. A committee is set up to review that after every 4 years. Indeed, you are probably paid something after the review, i.e. maybe you should have been paid 100 cedis per month, but you were paid 40 cedis. So when that commission carries out their work, they pay you something which is what you were supposed to have been paid at the beginning of the 4 years. But in your explanation, you said the public, that you don't take ex gratia. The difference is that you are still in your job. The member of parliament actually terminates at the 4 years. If he is lucky, he comes back. But indeed, you are also paid something at the end of the 4 years. Is that the case? You can call it a gratia, you can call it salary adjustment, but you are paid something. Is that not the case?
Everybody's salary is their legal right. So when you pay me less than what I'm supposed to earn, and later you tell me that this is what I should have earned, and you work out the difference and give to me, you're only giving me the balance of what I should have earned.
Oh, in that case, are you
Order.
sympathizing with members of parliament and ministers of state, since they are all accused of taking something they are not entitled to?
I cannot speak for them.
I have these ones are personal. Because of my profession, I noticed a news item recently that says that the court complex is in a serious disrepair. And indeed, when you go there, sometimes some of the floors and facilities are not fit for purpose. In fact, some of your courtrooms are on upper floors and your lifts don't work. I just wonder if a disabled person is seeking justice and the particular courtroom is on the 3rd or 4th floor. How are you able to provide justice to that individual if your lifts don't work?
That's an excellent question, but the comment you made earlier about the decay, etc., you need to remember that that building is right by the sea, and so it's experiencing the effects of the sea. So it's about renovation and repairing of the effects of the sea, and that's being done. We are taking steps in every direction. These things are a cycle, and we continue to do our best. Now, I said it's an excellent, the question about the disabled person is an excellent question, because if someone has to go up to the 5th floor for a case and the lifts are not working, that person is disadvantaged. So I think that the proper thing to do, and the thing that I really would hope the person would do, is to bring it to the attention of the law court manager, of the Chief Justice, of the Judicial Secretary, of the Registrar of the Court, anybody in leadership that they have access to, that this is my situation. And then the case can be transferred to a court that is more easily accessible. Because there's only one high court, and every high court, I mean, so long as the parameters of the case can be heard in a court closer to the person, that's the best thing to do. So it's just about giving information.
Okay. This House passed a law which is about disability. And that law allows the country to take steps within 10 years of the coming effect of that law to make sure that public buildings take steps to make them fit for purpose in terms of people living with disability. That 10 years passed maybe another 10 years ago. Don't you think instead of encouraging individuals to contact court officers and other things, we should rather try to enforce this against a particular state institution who has failed to implement fully the provisions of the Disability Act and serve as a deterrent to others to take the necessary steps? You may be surprised, even Parliament may be called upon to answer questions if we were to enforce that particular law.
If you recall, your question was about failing lifts, and that's the question I answered. It's not that the building is not accessible, but it may be on a floor that's not accessible because of a peculiar situation. That's what, and that's the answer I gave, that if there's a peculiar problem, it's important to respond to that situation. But so long as the building is accessible, I think that that building would have answered to the dictates of the law. I think every institution must comply with law.
I'm very grateful for that. And by the way, the breach of the law is not only on the upper floors. You could have a building on the ground floor, and the thresholds do not allow people with certain levels of disability to access that building. So I think the court should take a look at that and see if they can help the various authorities to implement the disability law. That will be very helpful to all of us.
My Lord,
Yes. Thank you.
My Lord, did the judiciary obtain building permit before constructing that court complex?
I will ask and get an answer.
Well, because I assume that before a permit is issued, all the legal professional issues relating to fit purpose would have been considered. So unless
Thank you for drawing my attention.
Thank you. Yes.
Speaker, I'm grateful for the opportunity. Let me quickly commend the nominee. Very impressive CV, and also to say that, Speaker, largely I am convinced, as she's dealt with the overarching issues that and observations that members have raised, except to ask a few questions. Honorable nominee,
Thank you, sir.
what will you seek to do in your first 100 days in office?
Work very quickly on practice directions and manuals. That's very much on my mind.
Thank you, Mr. Chair. Concerns about land cases, Honorable nominee, has come up, your ladyship has come up strongly in this country. And I heard your eloquent answer when you spoke to 3 factors: technology, case management, and I think lawyers, if I'm right. And as I listen to you, it appears to me that the matter is more complex than it appears to most of us. And for want of a better expression, it looks like a cul-de-sac. What, in your estimation, will be the way around this complexity?
See, reform is never a magic wand. It takes cooperation. It takes, very often we actually design programs, and you have to find the resources, you have to find the right facilitators, you have to do change management, you have to find tools and devices for ensuring that the reform is incorporated into the way we do business. And so it's a process. Getting anything done is a process. And I do not have any blinkers on that anything can be done so quickly just by promising, because I've worked in reforms for many, many years, and I've seen you have to think, start implementing. Sometimes you do user utilization records, you see that this is not moving as fast, you ask yourself what other intervention, you set up subcommittees. It's a human process.
Your ladyship, we've all come to this conclusion that ADR is a good concept to help us in the dispense of justice. And over the years, we have implemented it largely. In your view, what are the shortfalls, and given the nod, what will you seek to do differently in our bid to apply the concept of ADR in the practice of our justice system?
I think increase communication on how effective it is. I don't think people appreciate that settling a case in ADR can take you out of the court system instead of your being subjected to appeals for 5 years possibly. Because once a case is mediated and negotiated and settled, there can be no appeal. So it's such a useful tool for dispute resolution. And I think that it's about communicating it and raising resources for it. And don't forget that there's also legality around what makes it, what makes a settlement out of court valid. And so the education must also go to mediators and to stakeholders. So it's about increasing education, it's about increasing resources made available, and capacity building.
Your Ladyship, is it the case that education, as in its broader sense, is not being implemented in the context of ADR?
There's so much education going on. You know, we've had the ADR week for years. And in the ADR week, there's always media coverage. I recall the last ADR week was just a few weeks ago, less than 2 months ago. So there's a lot of education, but there's more that can be done.
Your Ladyship, this may be my last question on e-justice. And it's gratifying to hear my sector minister saying that she's ready and prepared to support in the execution of this all-important functionality. So far, what do you think we are doing right? And are you going to add on in terms of any innovative inputs in the practice of e-justice in our country?
I was vice chair of e-justice to begin with, and I'm the current chair, so that's what I'm doing. So, and what can be added on? In fact, there's a critical feature that we haven't been able to incorporate, which is affidavits, the swearing of affidavits, because the law requires that the one who's swearing the deponent must be before the commissioner. Now, technology means that you may well be apart. And then the signature is verified. So we have to work on the technology of the signature verification and also the virtual meetings between the deponent and the commissioner for oath. So whenever we meet any of those critical gaps, we have to work on it. And don't forget that e-justice has been incorporated as a matter of contract. So we have a contract for this phase that we are working on, and so we have to develop the next contract to fill in the gaps that we noticed.
My last question, Your Ladyship. Mr. Chair, I am an environmentalist, and I'm curious to hear your views on environmental indiscipline in our country. What, in your view, can the courts do to instill discipline in our environment and the way we treat nature in our country?
I think we are all harmed by the way we treat the environment. It affects businesses coming into the country. Investors are loath to come into a place where the environment is not attractive. So all of us are affected. And the courts, therefore, are open to do what we can do. But don't forget that we cannot sit on cases that are not brought to court. So someone must originate the matter. If that someone starts a case and that refuses to continue with it, we cannot compel adjudication. You see, so the courts have a handicap. The independent nature of the courts is a big handicap for us. It's not even a handicap. We ought not to jump into dispute into any arena. So sometimes people think that, people ask a question, can you see what is happening here? It's up to the citizen to bring a case to court. It's up to the Attorney General to bring a case to court if it's a criminal matter. And it's up to the one who is experienced it to bring a case to court. And not just bring it to court, but follow it through.
Mr. Chair, just to thank the nominee and also to wish her well. I'm grateful, Mr. Chair.
Also very grateful.
Honorable Deputy Ranking. Sorry, Deputy Chair.
My lady, the name Torkornoo, which part of Ghana does it originate?
Jamaica.
It's an Anglo name.
Okay, so where in Anglo State? Where in the Anglo State?
If I want to be telling you where my husband comes from, it's not my name. It's my husband's name.
Well, so, my lady, do I take it that you decline to answer the question? Which
He's
is also
from
your right?
Asadame. I hope
Where?
I've pronounced it right.
Where?
Asadame.
Asadame, close to Chairman, you mean?
Yes,
Okay.
in the Volta region.
Yes. So the name Torkornoo is from Asadame, which is a walking distance from Chame
Yes, sir.
in the Volta region,
Yes, sir.
which is part of the Keta constituency.
Yes, sir.
Okay.
Where do you come from?
So you mean that is your husband's name?
Yes, sir.
That's your husband's name, you said?
Yes, sir.
Okay. My lady, so you are a fanti married to an in-law man, meaning that your kids will be a combination of fanti Igwe, correct?
Yes.
Good. Now let me also ask you, page 4 of your CV. Page 4 of your CV. You were trained by William Edem Fugger.
Yes.
Can you share some few thoughts about this gentleman who trained you?
You can share thoughts about the training, what you learned in law, but not the person, please.
I think he was a sterling senior. I worked with him for 10 years and I learned a lot from him.
Clearly, as a person, you have no problem working with people of different tribes and ethnicity, correct?
Absolutely. I hardly notice anything like that.
Now, how long did you stay at Fugger and Co?
From 19 1987 to 1987 to 1996, end of 1996, December 96. Almost 10 years.
What influenced your going to the bench?
I was invited by the then Chief Justice Akwa. He was setting up the commercial division of the High Court, and he called me and said, "Would you like to be a judge here?" And I said, "Yes, sir."
All right, then that leads me to my next question, the Constitution. May we proceed to Article 144? So, first, 1441. So, from the text, it is clear that the appointment of the CJ emanates from the president. You agree with that?
Yes.
And then, from 1442, you would agree with me that the appointment stated there too emanate from the Judicial Council. You agree with that?
The president acting on the advice of the Judicial Council.
Yes. So
Yes.
therefore,
Yes.
it emanates from the Judicial Council. In other words, until the Judicial Council so nominate, the president would have nothing to do with anything, correct?
The appointment is by the president acting on the advice of the Judicial Council in consultation with the Council of State and with the approval of Parliament.
No. My lady, let's, you said your philosophy is grounded on text. So maybe
Yes.
let me read it aloud. There's other Supreme Court justices shall be appointed by the president acting on the advice of the Judicial Council in consultation with the Council of State and with the approval of Parliament. So we'll pick it one after the other. Yes. So the language in 1441 obviously is different in form and in substance from 1442. You agree with me on that?
Says the other Supreme Court justices shall be appointed by the president acting on the advice of the Judicial Council in consultation with the Council of State and with the approval of Parliament. 1441 says the Chief Justice shall be appointed by the president acting in consultation with the Council of State and with the approval of Parliament. So what is taken out is the Judicial Council, the role of the Judicial Council.
Yes, but if we pay attention to 1442 again, are you saying that the president will initiate and seek the advice of the Judicial Council?
I haven't said anything. I'm waiting for your question.
Yes, no, because my question was 1442, whether or not these appointments stated there too emanate from the president. No.
I think you are asking me questions about the practical workings of this. And I would imagine that the practical workings of this may not fit squarely into this. I don't know how the president starts the process. And the Constitution gives us the structure. But the nitty-gritty of it, that would belong to...
No, my lady, let's go practical. I'm not being hypothetical here. When my lord...
What exactly is the question?
Yes. You see, when my lord Puaman and my lord Apau were appointed, you may recall that the Ghana Bar went to court. And when they went to court, they questioned why my lady Mensa Bonsu and my lord, the late, the man from Asen, Mafusao, could not make it to the final appointment. And the position of the Supreme Court was that the Judicial Council, in making recommendation to the President, did recommend all these four. And the argument of the bar being that once it is done in a certain order of merit, the President was bound to follow the advice by making an appointment in that order. Therefore, since Mensa Bonsu, Professor Mensa Bonsu and my Lord Mafusao came before, in that order, before my Lord Apau and Puaman, the President should have considered them first. So I'm saying that by that interpretation by the Supreme Court, 1442 was settled as to how appointment is initiated. In other words, it is not the President who initiates those. I mean, that's how I understood it to be. I want to know whether you agree with that.
I suspect the structure of the ratio that you have put out may be slightly different from how that decision actually went. I want to consult with my
it's in court. I was part of it, so I remember clearly.
I was not.
So I can. No,
I
no.
was not part of it.
I agree. I'm not saying so. My lady, I'm not saying you were. You were at the Court of Appeal then. You were not there. You are not there. So I'm just giving. If maybe you may want to consult and revert.
And that's why I said I suspect that the ratio may not be exactly as you're articulating it. So I want to clarify. If my lords behind me remember the ratio of their decision,
you may do so.
No, please. Honorable, my lord, you're not permitted to consult behind you, please.
then very well.
I'm
unable to answer the question.
That's please, that's fine.
I'm unable to, because the ratio of a decision is very important. And I don't want to presume.
Let's be clear. Has my lord read that decision? Very well.
No.
My lord, I brought this up because when we had the last vetting here of my Lord Jehu and others, some of our colleagues raised issues about unfairness, discrimination, and what have you regarding promotion to the Supreme Court. I therefore wanted your view having regard to Article 153, which gives a clear list of the composition of the Judicial Council, which has clearly a number of independent individuals constituting that body. And it's only 4 non-lawyers appointed directly by the President and the Attorney General. These, I would say, 5 out of the whole lot who may be. Now, I just need you to give assurance to the public that having regard to Article 153 of the Constitution, really the major role played by the Judicial Council is key when it comes to appointment to the Court of Appeal and the Supreme Court, and not solely on the president, so that the issue of discrimination could be brought to rest.
I understand your question. Yes, and from the way you framed your question, I can appreciate the angle of clarifying that the Judicial Council as a body is structured to have a lot of different voices. And we have a Justice of the Supreme Court nominated by the Supreme Court itself on it, a Justice of the Court of Appeal nominated by the Court of Appeal itself on it, a Justice of the High Court nominated by Justices of the High Court, 2 representatives of the Ghana Bar Association, a representative of the regional tribunals, a representative of the lower court, Judge Advocate General of the Ghana Armed Forces, head of legal directorate of the police, the editor of the Ghana Law Reports, a representative of the Judicial Service Staff Association, a chief nominated by the House of Chiefs, and 4 other persons who are not lawyers appointed by the president. And all of these people have to be part of the decision making. If that's the clarification you are seeking, it's evident from the content of the Constitution.
Yes, exactly the point. So, should you become aware that there are very senior people who would have to be considered and feel discriminated against, would you take steps as a chair of this body to initiate processes leading to their elevation, just to also make them feel fairly treated?
As chair of the Judicial Council, the Chief Justice will definitely be privy to the whys and hows of all promotion. And I think that's where I'll be coming from.
All right, so let's go to the Gertrude case. In this ruling, the reasoning of the judgment is not yet out. But you consider the orders you issued to be executable orders, correct? And
yes.
Right. And the affected party can either appeal, file a review of the decision, or perhaps apply for stay of execution. Now, would you agree with me that in the absence of the judgment, it will be difficult for the affected party to exercise certain rights in respect of the decision? Would you agree with me?
I agree that anyone who obtains a decision from the Supreme Court is entitled to apply for review if they meet the threshold for review of the decision, because there are very clear parameters for review. I also agree that without a copy of the reasons, it will be difficult for them to know. And so it's necessary for them to get a copy of the reasons.
My Lord, permit me on this, and this is for our collective consumption. You see, earlier my colleague Ayariga raised an issue regarding this matter. We are the politicians. You pronounce on our conduct. And when there is ambiguity, there's confusion. To get our heads out of the cloud, we need certainty. Right now, Electoral Commission, which was a party to this decision, cannot act. The Speaker who must exercise certain rights under Article 1125 may or may not act. I'm saying that though you have the right to pronounce on the matter and reserve your reason for another date, you may have to look at how you approach this or exercise such discretion in matters that are politically sensitive. Else, we are all thrown into a state of confusion, insincerity. Because right now, you've made a pronouncement there, but that pronouncement that you've made, we've only heard it in the air. Is there an order? What if the party will file a stay? What if the party will file a review? Now, can the Electoral Commission immediately go and announce a date for by-election? What if it does that and the party, after receiving the judgment, decides to file? And you're also aware that in the recent case that you outlawed a provision in that Narcotic Act, my Lord Professor Kote departed, moved when he came on review recently. Was originally with the minority, and now with the minority. So it means that anything can happen. So I'm just drawing the attention of the bench to some of these things which could affect the.
I've seen my Lord shaking his hands.
No, but that's my Lord, with respect. In the case, let me refer.
Proceed with the question. Lord Roberts, please. It's not really a question. It's an answer.
Mr. Chair, you know that we are dealing with the matters that are happening. I believe that if we all get the opportunity to get it clarified, it will help all of us. But if it doesn't please Mr. Chair, I can drop it. All I'm trying to say is to draw your attention to some of these problems, because you had said you have a discretion to reserve your reasoning for a later date.
Thank you. What I said was that because of the nature of the panels, we take time with the decisions to make sure that every jot and every tittle is accepted by every member of the panel, because all of us will put our hands to it. But the core content of every judgment is accepted by a panel member who says they agree. So the point you make is well noted.
So in other words, the point I want to make is that the bench must be mindful of decisions that have political connotations, so that you don't set us on a collision course as a political class. That's the point I want to make.
Point is well noted.
My lady, you were appointed to the Court of Appeal by President Mills of blessed memory. And according to you, the former late Chief Justice Akwa mentored you to the bench. And today, you are being nominated to the Supreme Court by Nana Addo Dankwa Akufo-Addo. How would you describe your career path within the context of these appointments?
I was nominated while President Mills was alive, but I do recall that I was sworn in by President Mahama. At the time I was sworn in, President Mahama was the president. And I'm wondering how to answer your question, because you mentioned different people who were key or who were in leadership at the time I moved to different stages. And then you said, how would I describe my career path? I think that my career path has been satisfactory. I have done my work. My work has been recognized, and I have moved forward. I think I spent about 7 or 8 years in the High Court, another 7 or 8 years in the Court of Appeal, came to the Supreme Court, and here I am. I've just moved on after working for some time.
So in other words, you have risen by merit, and there's nothing partisan in your career.
I would agree with that.
My lady, what is your view on death penalty? What's your view on that?
As a justice of the Supreme Court, I'm mindful of the fact that when cases come to court, if a case came to court, it would be my duty to preside over it. But on a personal level, I do think that the death penalty is too final, and it's something that I would be grateful if the legislative body can begin to look at it.
My Lord, if I shot your daughter, it would be final, wouldn't it?
It would be, but you see, in criminal law, we are always looking at the mens rea, not just the actus reus.
Is that not the essence of a trial? That you take all the necessary evidence and circumstances and everything you want to consideration versus the law and come to a conclusion that I shot your daughter, intended to kill her, and I did kill her, and therefore I'm guilty of murder. Would not that be how you would come to a conclusion?
With all due respect, Order 69. Mr. Chairman, Order 69.
You're sharing about people saying we are quarreling, but I control the proceedings. If you want to bring anything to my things, you know what to do. You don't, no, not by speaking into the mic.
Mr. Chairman, with all
Can
respect.
you please hold on? Let me conclude what I'm saying. My Lord, I was asking that if...
Kindly use another example, not my daughter.
You see, Mr. Chairman, exactly. Order 69 says that you have been speculating. And that's
well, that's exactly the point.
You shot Madam X.
My Lord, if I use Madam X, the emotional response will be different. So he who feels it knows it. So when we are arguing about death penalty being final and so on, it is when the shoe is on the other side. You see that using your daughter's example gives a different feeling. That's all the point I want us to draw.
I know your views about this, man.
You've done a
my
good
views are
job.
very strong about that.
Yeah, so my lady, let's
Commit offense and they come.
my lord, let's go to the recent case of the Ezuami Manan versus Attorney General, where the law we passed, you had reason to strike out certain provisions, and you also admit that parliamentarians do a good job. When the memorandum comes, it goes through win-win, committee meets, do the report, and eventually when we come to the floor, we debate amendments are made and we arrive at the final provisions of the bill, which is passed. Now, in view of what has happened, would you recommend a certain fusion in terms of the relationship between the judiciary and parliament when it comes to lawmaking, such that we can have a certain hybrid committee of a sort, which would have your input to look at some of these bills? Because my lady, you would agree with me that decisions of this nature, much as you may be well intended and you may be right in your opinion, it doesn't augur well again also for the relationship that exists between these two organs of state.
You see, we have different functions in the constitutional order, and these occurrences don't happen every day. They are very much the exception, and so so I don't think that we should be setting standards around them, around exceptions.
How exceptional do you think this is? Because there is a law that we've passed as Parliament. How do you see it as an exceptional situation?
How many laws have you passed this year? How many of them have appeared in court? The point I'm making is that the regularity or the times when enactments and activities are brought to the Supreme Court, there's a wide spectrum that they do not match up to the constitutional standard. There's a wide spectrum, and we consider these within every fact situation, and the panel that sits on it makes its decisions. That is our job. That you do your job, we do our job, and together we serve the country.
So you disagree with any fusion that would allow an overlay of relationship to help deal with some of these situations, so that
absolutely.
we don't create
we cannot
problems of
no, absolutely. I
having
think
a
that
banter.
if you keep your eye on the Constitution and keep your eye on your own, everybody has their remit. Everybody has their remit, and there are good reasons for that.
My lady, you are obviously an inspiration to women. You have
Thank you.
You have developed your career at the bar, you've gone to the bench, and now the Chief Justice nominee, if all goes well, you'll be sworn in. What have you to say to women, young girls, who are in self-doubt about their own prospects in life?
I would ask them to be confident in themselves, to work on the areas that create the self-doubt, to choose not to look down on themselves, to choose to appreciate that they are valued, they are persons of value, and that they are entitled to sit at the table. Every girl is entitled to sit with her brother at the table. That's what I would say.
Mr. Chair, nothing useful to ask again. Thank you.
Yes, Honorable Ranking Member.
He's been around for 1 hour. Good afternoon, my lady.
Good afternoon, the Honorable Member from Ejumako, where I went to primary school.
Thank you very much. My lady. My lady.
Where she comes from.
I noticed on your CV that you spent some time to study in Ejumako, my constituency, and you did your primary school and middle school in Ejumako before you went to the Wesley Girls. So the people of Ejumako are proud and they are happy to see that someone can move to that level.
Thank you very much.
However, Ejumako has always produced people with integrity, and we have Ejumako values that are often instilled in us. That will mean that no one can push you over. I hope and pray that you still have that values, that you will not be a pushover.
My values have been produced by all that have made me. My parents, my home, my schools, everywhere I have lived, my faith.
My lady, in a recent case in the Supreme Court in which by a unanimous decision of 5-member panel, you were disqualified from participating in a particular case. And the case has to do with Ecobank Ghana, Securities and Exchange Commission, and the Ghana Stock Exchange. Correct?
Yes.
What was the reasons why you were disqualified?
You know, I started my career in the commercial division of the High Court. And in the High Court, sometimes there were so many cases from one particular source against different parties. So this case happened to be one of those kind of cases where different parties had different issues in different suits. And I sat on one of them. So when the matter came up to the Supreme Court, I was very clear that the one I sat on is not this case. And so I refused to recuse myself. And that's how the disqualification question came up.
So you recused yourself, you failed to recuse yourself because you weren't sure that the case was part of it?
No, I refused to recuse myself because I was sure that what I had handled in the High Court was distinctly different from what was in the Supreme Court.
My lady, on a hindsight, could you have recused yourself when the objection was raised by the parties?
I would not do things differently.
Finally, so you were at the High Court when the case was determined, and you knew from day one that you were dealing with the same case.
Absolutely not. That's why you see, in the commercial division of the High Court, it was easy to find a particular bank suing so many different people, find a particular plaintiff suing so many different defendants. And I was quite clear that this genre of cases were very regular in the commercial court, and so they should not be an issue in the Supreme Court.
I'll now take you to the issue relating a ruling that you actually wrote, the lead ruling, in the case of Honorable Peter Amewu, the Hoho case. Madam, do you remember you wrote such a ruling?
Yes, the certiorari application.
The ex parte.
Yes, I did. The review.
The review.
Yes.
The Supreme Court, in respect of the Hohoi case, in particular, quashed the order of interim injunction against the Honorable Amewu, right?
Yes.
On the basis that only an election petition could the High Court invalidate the election of a member of Parliament, isn't it? You wrote in the ruling, and if you are to look at the ruling, that I have a copy here, I may refer to page 15 of your ruling. Page 15 of your ruling. It says, the validity of a parliamentary election and its outcomes must necessarily be prosecuted through a parliamentary election petition in the High Court, and neither the Supreme Court in its several jurisdictions and the High Court in its various jurisdictions have the jurisdiction to grant a relief relating to a parliamentary election without a hearing conducted via petition to question the elections of the High Court. Do you still stand by that, Honorable Nominee?
The distinction between the distinct features of that case that you have just read out of was the action was commenced as a fundamental human rights action. Then within the fundamental human rights action, questions regarding the validity of an election were raised. So what we pointed out, that is the reason why the orders relating to the validity of the election were quashed, because the validity of an election must be questioned in a petition, not in a writ. So the mode of commencing the action, the jurisdictional territory of the High Court, all of those were in conflict with the decision. And what we did was sever the invalid part from the valid part.
My lady, most importantly, in the same case, you cited a case involving Mr. J.H. Mensah, the former senior minister. And I've read the judgment. You cited a case involving the senior minister, J.H. Mensah. In that case also, the Supreme Court said that it did not have jurisdiction in respect of a parliamentary election. Isn't it the case?
The J.H. Mensah case started out of time. That is how all the difficulties started with that case. And then it was also, I think, started with a writ. So it had a lot of procedural difficulties. And then an aspect of it was brought to the Supreme Court on a constitutional question. And the Supreme Court once again severed the issues.
My lady, I also need to know whether you were part of the panel in the Quaison case that granted the injunction.
I was. Oh, I am.
I'm building a point. In that case also, my lady, the validity of election, someone's eligibility as a member of parliament was challenged, isn't it?
Yes.
And this was around the time Parliament was considering a particular legislation on e-levy, isn't it?
I can't remember the exact month the e-levy issue came up, but that was last year or so. Yes. I remember sitting on the e-levy matter, but that was last year. That matter is not concluded.
That matter is not concluded, obviously. It's before.
My information.
Will never be concluded. Will it ever be concluded? No. It's not in there.
Do you have an idea when that matter will be concluded?
That one, it will take forever.
When the plaintiffs prosecute the case.
My lady, in the last week, there was a Supreme Court decision on Kwesi's case. Obviously, from what we've seen as part of the judgment, you were part of the panel, correct?
Yes, I said so.
Will it be wrong for me to say that the Supreme Court invalidated the parliamentary elections in Asen North?
That invalidation was done by the High Court last year. Was it last year? We are in 2023. I think the High Court's determination was in 2021. It concluded in 2021. Then there were appeal proceedings, etc.
And lady, our major concern has to do with we in the minority, our major concern emanate from the fact that we don't have the reasoned ruling for us to be able to ask you questions as to the reason why you arrived together with the panel at that conclusion. We have been informed that the court, the Supreme Court of Ghana, will give the reasoned ruling on the 7th of June 2023. Now that we do not have the ruling, and the fact that we want to ask you questions on it, what do you suggest we do?
I think one Honorable Afenyam Markin has drawn my attention to the need for the Supreme Court to appreciate the effect of any delay in giving out the reasons when it comes to politically sensitive cases. I can assure you that we deal with every case the way we deal with every case. And so in this particular case, I think earlier on in the day, I said that because we are a 7-member panel, we work in a particular way. And I said I had taken note of his concerns.
Justice Gertrude Sabasaki, Torkornoo. I need to find out from you if you are aware of the Baba Jamal case as well.
I am aware of it from the books.
Are you aware that in the same Baba Jamal case, the Supreme Court ruled that they do not have jurisdiction, and it's the High Court that will have the jurisdiction on the matter?
They will not have jurisdiction. You know, I think the point has to be made clear. Different courts have different jurisdictions over different matters. The Supreme Court is the only court that has jurisdiction to interpret the Constitution where there is the different interpretations are being placed on it by disputing parties. So our jurisdiction that is exercised under a constitutional interpretation jurisdiction is different from the jurisdiction that's exercised by a different court under its particular jurisdiction. It's important not to mix it.
They are running away from it.
Lady, yesterday, I received a letter from the Office of the Attorney General and the Minister of Justice. The letter was addressed to the Right Honorable Speaker, Parliament of Ghana, Accra, and I was copied as the minority leader. The letter seeks to inform Parliament about the recent ruling on Kwesi. The letter, the third paragraph says that on the 17th of May 2023, the Supreme Court delivered judgment in the suit and granted the following reliefs, and there are 5 reliefs. Since you are aware of the reliefs, there's no need for me to read all of them. But let me read the last one, the last relief. It goes on to say that finally, Parliament is ordered to expunge the name of the first defendant, James Gyakye Quayson, as a member of Parliament for Asen North. The third paragraph in the second page reads, the effect of this judgment of the Supreme Court is that the election of Mr. James Gyakye Quayson as a member of Parliament for Asen North constituency is unconstitutional, null, void, and of no legal effect. The final order of the Supreme Court for Parliament to expunge the name of Mr. James Gyakye Quayson as a member of Parliament for Asen North means that Parliament is to completely remove any record relating to him as a member of Parliament, and implies that a vacancy has occurred in relation to the Asen North constituency. My question is, how does Parliament expunge Honorable Quayson's name from Hansard, for instance, that has already been published? How does Parliament, for instance, go back and expunge Gyakye Quayson's name from vote and proceedings or all parliamentary document that has been distributed across the world? Don't you think that the meaning that the Attorney General, the AG, has enlightened in the document before us will be very difficult to implement? What are your views about the matter?
I will not be able to give you my views on what the Attorney General has said.
So, can I put it this way? The Attorney General, in his view, has explained the meaning of your faith relief. Do you agree with the Attorney General's meaning to the faith relief as in your judgment? Or what is the meaning of the faith relief in your judgment?
Could you kindly read the faith relief?
The faith relief says that finally, Parliament is ordered to expunge the name of the first defendant, James Gyakye Quayson, as member of Parliament for Asen North.
That is what it means. That is what it means.
Madam, so if we say expunge, is it going forward or all the records that he has been involved in?
Honourable members, order. Kindly allow the nominee to.
The decision.
Honourable members, can I have some order, please?
Any decision of the Supreme Court is a decision of the court. And it is also allowable for any party who does not understand what the court has said to seek clarification from the court. So I would humbly suggest that if there's anything in our record you don't understand, that you activate the procedures. But otherwise, I don't know what else to say.
Madam, we will wait for the ruling, the detailed ruling, and we'll ask further question on this matter. But let me also ask this question. As a layman, I'm very uncomfortable anytime I see the Supreme Court itself hauling individual persons before the court for contempt. To me, it appears to be the court is acting as one complainant, two prosecutor, and three, a judge. I want to know what is the practice in other jurisdictions so that I'll be guided by that.
This is the nature of the contempt relief. A party can bring an action before a court for contempt if the party finds that another one is not obeying the court's orders. Then the court itself can commit for contempt when the contempt is carried out in the face of the court. So there are different ways in which that application or that relief can be obtained from a court. A court is supposed to protect the dignity of the administration of justice.
Madam, some Ghanaians believes that this is an abuse of power. Can you explain to those concerned Ghanaians that for some reason they believe that this is an abuse of power, that it is not an abuse of power, in your view?
To be honest, it is not an abuse of power. You see, the judicial process is integral to the peace of a country. Honorable Member, the judicial process is integral to the peace of a country. And that is why I believe even this relief constitutes part of the processes that may be commenced by a court itself. It's not an abuse. And any party, I think if not too long ago, the Honorable Chair drew my attention to the fact that when something happens to you personally, then you know the effect of it.
My lady, recently, the immediate past Chief Justice, Justice Enin Yabua, ordered for the appeal courts at the regional levels to be removed. The one in Central Region, for example, in Cape Coast, served Central and Western Region, and in some cases, Western North. The one in Tamale serves all the northern regions. Will you consider bringing the appeal courts back, considering the fact that it serves Ghana well after 10 years of operation? Will you consider?
I worked in Tamale, in the Court of Appeal in Tamale. And there were times when we could travel by air, have to live in a hotel, and there were very few cases. The times when we had to wait for 3 months to ensure that there were enough cases to be handled, commensurate with the cost. And yet, that 3-month wait was not good for the parties who had to wait for us to come there. And I think that some of these considerations were part of the reasons why the Chief Justice and the Judicial Council thought that it was appropriate to limit the sittings of the Court of Appeal in some of the different places that they had been operating. When you sit in the Court of Appeal in Kumasi, where I sat, the list is very tall. Compared to the list in Tamale, is very short. So some of these considerations, administrative considerations, arise.
In this era of e-justice, will you consider online hearings for those who will seek the service?
Absolutely. When I worked in Kumasi, we often gave judgment from Accra. The registrar would come from Kumasi to Accra, and we had a facility in Kumasi where the lawyers would be in Kumasi and could see us and we could see them. And because we were sitting in Accra, the court was properly constituted. Because we were sitting, the court was properly constituted, and we conducted business and delivered judgments. So we used the virtual court system for delivering judgments in matters that we had heard in Kumasi physically. So I agree with you.
Madam, if you are lucky enough to go through Parliament and to become the Chief Justice, what will be your legacy? For the avoidance of doubt, I'm building a question.
I hope to leave a legacy of extreme efficiency in the delivery of justice, the use of rules efficiently and effectively, a legacy of intense training, raising of excellence in the standards of the judiciary, a legacy of use of technology, a legacy of publications.
Madam, I want to know if all judges are given equal opportunity when it comes to promotion.
So far, I haven't been part of the decisions to promote, so I cannot say for sure, but I would believe so, that there are considerations, objective standards that are used.
So may I also know what is the role of the Judicial Council, the Ghana Bar Association in promotion, if they have any role, anytime promotion issues comes up, if they have a role?
The Judicial Council has a constitutional role in judges moving to the different levels of court. The Ghana Bar Association is a major stakeholder represented on the Judicial Council.
As a Chief Justice, if a matter comes to your attention that someone has been promoted, maybe in error, what action will you take? Or he doesn't qualify to be promoted, but for some reason has been promoted. What action will you be able to take, or will you want to take?
I believe I will not consider such a situation by myself. I will do so with all the stakeholders.
You mentioned that you would like to leave a legacy if you are fortunate enough to go through Parliament. Efficiency and all of that. Currently, if someone wants to assess the efficiency of the administration of justice system in Ghana, do we have some policies that are available for the public for us to be able to assess? For example, human resource policy and promotional policy for judges. Do you have a policy relating to judges' promotion and human resource?
I believe we have human resource policies.
What about promotional policies?
I'm yet to review such documents. I haven't been given the position of Chief Justice, so I'm not privy to these documents, these policy documents.
Madam, in a related case, you had earlier on indicated the cost of the e-justice system. But in another question that was put to you on the cost of the relocation of the judges' bungalow, now the site for the National Cathedral. You said you have not yet been there. Why is it that in one breath you know the cost, in another breath you don't know the cost?
Because I'm the chair of the E-Justice Committee. It's my duty. It's what I do on a daily basis. I preside over all issues regarding the e-justice. That's why I know.
May I know your views relating to a popular statement that goes around most female in this country relating to removal of taxes on menstrual product? I want to know your views on that.
I believe the relevant ages for females who are who are in that biological state commences from somewhere around 10, 11 years up to 50 years. Now, if you're dealing with products for school-age children, I think they should be tax-free. But if you're dealing with products for working women, I don't think they should be tax-free.
Well, it's your view, so I don't really want to go in. I just wanted to know your views. So, my last but one question. I did not impose that, so for your record. And in any case, you've been in government for 6 years, and you are failing to remove that. Madam, I want to find out from you whether you are aware that there is some perception out there that the Ghana's judiciary, the image is going down. It is not as we have been aware of, because you hold the state together regardless. Have you come across some of these views?
I know that in many circles, you hear very high reviews of Ghana's judiciary. And as I've said, it's a human institution. So we have our faults, we have our strengths.
I think if you are fortunate enough to occupy a high office of a Chief Justice, one thing that you should consider working on will be the image of the very noble institution of the judiciary.
Thank you very much for that. Thank you for contributing that thought.
But, Madam, have you declared your assets since you were nominated as a judge at the Supreme Court?
I declared my assets, I believe, just last year. It's a 4-year cycle.
Madam, are you also aware that the same legislation talks of updating it anytime you acquire or dispose of an asset? And I want to know whether you've been doing that, yes or no.
I don't think I've acquired any new assets since I declared it.
Honorable Chairman, to conclude on the vetting for today, we have asked all relevant questions that has come to our attention, apart from the matter we raised relating to Honorable Kwesi. we in the NDC minority believes that we should be given the opportunity to question Justice Gertrude Isaba Saki Torkornoo on the real ruling. We are asking for an opportunity to be able to interrogate the reasoned ruling. And so, just like Honorable Ayariga had said, and we have said, we have started the process, but we want an opportunity to conclude on that particular matter. Then we take a decision. Thank you.
I regret that the ranking member puts his side view as if it's a decision of the committee.
No, that's not what I said.
No, you can't say to conclude. No, you must ask the question before you conclude. No.
I didn't.
Let's make it clear. I think that we are confusing our role here. Our role here is regulated by our standing orders. The standing orders, this committee has not precluded anybody from asking any question of any sort. Indeed, there are some few questions I could have intervened, but I decided that let the process flow. So it is open for anybody whilst we are here to ask any question. But please, let's not appear that because a judgment of a court, not her judgment, the Supreme Court, you have not had a copy, it in any way precludes the Appointments Committee from concluding its work. I don't think we should encourage that kind of announcement. But it is my turn to ask questions now, so please let me proceed. First, let me start by clearing this issue relating to Parliament not having records of the Appointments Committee consideration of this nominee when she appeared before us at the Appointments Committee in 2019. I have in my hand a copy of the report that this committee placed before Parliament. It is stamped Parliament Library. Now, this committee, its report, its proceedings are not recorded in the Hansard. So the verbatim report is not recorded anywhere. But the recordings are available, and if any member applies to the audiovisual section, you get a copy. Because it is important that what has been placed on record, our public record, it should be clarified. This was brought to me by the committee, the clerk to the committee. I didn't even have to apply for it. So, yes, there is record of what we did. There is record of the report we placed before Parliament, and a copy is available in the library. But the Hansard will not have a verbatim report. If that is what my friend was talking about, then probably somebody misinformed him about our Hansard report. But can we do this after? Now let me finish my questions, please. Honorable, my lord.
Yes, Chairman, I agree with you that the information you have given or you have been given is correct. And that is not what I said when I raised the issue with our data management, because I also have received a copy of the committee report and also a what do you call it? The Hansard. I have the committee report and I have the Hansard, and those are there. But I applied, like you are suggesting to me to do, to the audiovisual department for a verbatim recording of the evidence. I did, and I was told that it is not available.
because they do not back it up from here. And so these are the details we can discuss. But I'm saying that let us take note of this. And if we have to equip the audiovisual department to keep records beyond 2, 3, 5 years, we should consider that. But the point is that the audiovisual department does not have a record of the first time she appeared here in 2019. That's just my point. Thank you.
Very well. This is what the audiovisual department brought to me. What they stated is different, but that's fine. That's why I was insisting that that matter should not be discussed in public. But he insisted on putting it out in public, so it was necessary that I correct as well. My Lord Isaba Saki Torkornoo. I have a report before me which makes something I've heard other lawyers say. The report says she seemed to be strict and not approachable. Not approachable is interesting to me. Being strict, I agree with you. If you're going to be a good leader, you have to be firm and strict on the rules. But not approachable. Is it a fair reflection of you?
I really don't think so. Because, as I said, I've led the e-justice team, and that involves a lot of people. I work with them. I've been supervising judge of the commercial court for many years. That is a teamwork with all the judges of the commercial court and all the staff of the commercial court. I have worked as chief editor of the AMJG bench for 10 years and more. So I think I've worked with so many different teams. Maybe what is peculiar about me is that if I have no business in a place, I don't go there. And usually when I'm walking around, I keep my head down because contrary to what people may imagine, I'm a bit shy. So if that is what has been translated as not approachable, maybe I have to start looking up some more.
Very well. I'm also interested in another part, that she is a woman preacher at the International Central Gospel Church, ICGC, Calvary Temple at Torkornoo. Now, the reason I'm worried about that is that, yes, in this society, everybody seems to think that if he has access to you, he must seek to influence what you do or ask you for a favor. How will being a preacher in a church affect your work as a Chief Justice should Parliament approve you?
Well, I'm a lay minister, and I'm not a full-time pastor in the church. But I have been in the same church. I was in that church before I joined the High Court. And I've been in the judiciary for almost 20 years. And I don't think that anybody has ever attempted to compromise my integrity. Maybe that's what they mean by not being approachable. I suspect that is what it is.
Let me bring you back to the issue of death penalty. Do you find anything wrong with the existing law on death penalty?
No, I expressed my sentiment as an individual that I thought it's very final. I didn't express my thinking as a judge.
Should a judgment be very firmly and fairly concluded that the person has committed murder, not just killing, murder, intentional, would it be unfair to execute that person in satisfaction of the law?
Your question is about executing. It's not about sentencing. I'd like
Very well. Very well. Well, is it because today what even I hear is that
because our role is limited to sentencing.
Very well.
The execution part is not part of our work.
Is there anything wrong with sentencing such a person to death as required by law?
Sentencing is always guided by law. And so long as the law says it, I cannot dispute it.
Now, don't you think that your lay position, your preacherhood is influencing, or your Christianity, so to speak, is influencing your perception of the death sentence?
I don't think so.
Very well. Let me say that there's just one more thing about the last 2019 when you appeared before us. You asked a question on contempt, and you suggested that because as a quasi-criminal offense, the punishment that can be administered is not defined. You may suggest that Parliament may wish to regulate what kind of punishment be. But I look at the Constitution, and the power is given to the Supreme Court to determine what is contempt and to administer the exact the punishment that is appropriate.
Remind me of the provision so I can follow you.
Sorry. Article 126. The Superior Courts shall have the Superior Court shall be Superior Courts of record. They shall have the power to commit for contempt to themselves, and all such powers as are vested in a court of record, immediately coming into the force of the Constitution. So the power is vested in you. If you think that a sentence should be defined, don't you think that you have jurisdiction, as you suggest you would prefer, practice directions? Don't you think that the Chief Justice may have, through practice direction, have the power to regulate how punishment should be exacted for contempt?
I think the Chief Justice may have a problem if the Chief Justice tries to set out punishment for the penalty for anything, because that's the preserve of Parliament. That's the preserve of statute. As it is now, the penalties are determined the gravity of the offense, how the court assesses it.
In Article 122, what constitutes contempt for Parliament has been also provided, and Parliament has provided the procedure for in our own standing orders. The standing orders are internal. I was thinking that if you let me start from Article 122, an act or omission which obstructs or impedes Parliament in the performance of its functions, or which obstructs or impedes a member or an officer of Parliament in the discharge of his duties, or affronts the dignity of Parliament, or which tends either directly or indirectly to produce that result, is contempt of Parliament. I think in form and substance, it's not too different from contempt of court. But when it comes to how Parliament exercises power, it's standing orders, which is not an act of Parliament, so to speak, an internal regulation. We have regulated how we should proceed with. Don't you think that the court can do
Suggestion is well noted.
very well? On that note, I wish to bring proceedings to a close, but I encourage political commentators to be very circumspect in our choice of words regarding the institutions of state. I find it very, very unacceptable that talking to one another, we are very abusive. We insult one another freely. And then we extend that to bodies like the judiciary, whom we would run to even when we cannot agree. I think that particularly politicians who are lawyers should be seen to be standing up for the judiciary, because unfortunately, unlike us, they cannot speak for themselves. They cannot. But so I suggest, I'm hearing Honorable Suyini say independent on where, but it is the same thing. Whenever a party is in opposition, they argue that the Supreme Court or the court is biased towards them. So the statement is to all of us. I'm not differentiating. So what I suggested, that those of us who are lawyers, we should take the responsibility to protect that institution, because like Justice Lawyer Mayor said, the bench and the bar, we are the same thing. You may find yourself living here and joining them, or going to practice in the bar. If the court is not respected, we will have nowhere to go to when we have challenges. On that note, I thank you for attending upon the committee to answer questions. It's been a very long day. But before I discharge you, let me recognize the presence of the immediate past Chief Justice, my Lord Justice Akwesi Ending Yaboa, the Acting Chief Justice, my Lord Justice Jones Doche. I've seen the Judicial Secretary. Yes, I'm recognizing all the Supreme Court judges here. The Judicial Secretary is there, isn't she? Yes, please. Very good. You want me to recognize Justice Kote, but our lecturers are too, Justice Kote and Mrs. Mensah-Bonsu. They all taught us. But I hereby acknowledge and recognize all the members of the Superior Court bench and some other prominent Ghanaians I've seen. Yes, the President of the Bar Association and his executives and other members of the Bar Association. I see the husband, the former. Don't worry, when an architect comes, I'll give you the space to do everything you want to say. Mr. Torkornoo, I recognize you. And if there anybody having my Lord Justice Pama has okay. He was Justice Scott, so we call him Scott J. You know, there's SRC Electoral Commissioner. Is that right? So we thank you so very much for coming to assist us to conduct this public hearing. You are now discharged.
Thank you very much, Honorable Chair.